us or the other couple of people that I mentioned. So again, I'm thinking in terms of how much this jury has to take in over a month's time. And I recognize what Your Honor did say yesterday about, this jury can sort of discern what's important or not. But my point, I think, should be they don't know until the court gives instructions what's important, what's not. So, I've never been a juror. I've done mock trials and I've been a mock juror. But when you're spending a month and there's going to be hundreds of exhibits perhaps before we're done, if the jury doesn't at least have an idea of what's not important rather than going through each item, I'm asking that the court exercise some discretion to limit that type of testimony, because by the time this jury is done, they're going to be dealing with items. They have to go through everything. The court's going to instruct the jury, I assume. They have to review everything and make before they deliberate, and how they do that is up to them. But they're going to obviously be some people want to go through every single item. We could be here, it could be a week before they even get to the point of saying, now we're going to start deliberating. That's my concern, after they get the case.
Well, the court is always interested in efficiency. However, just to use a musical analogy, if the state wants to use 4 quarter notes per bar instead of 1/8 notes or 16th notes, the court is not going to interfere with its style. However, if counsel for the state and the defense come to some agreement as to whether there would be objections if there were offers of exhibits that ran as a chain, the court would certainly encourage counsel to discuss that.
Well, in that vein, Your Honor, I'll note that yesterday, Mr. McGinnis and I reached an agreement. There's that unrelated white, he can correct me if I'm misstating, the white T-shirt, the Hanes extra large white T-shirts that's shown in some of the photographs that was found in one of the trash barrels. The state and the defense are going to stipulate, I don't know if you wanted to do it in writing or just verbally, because we talked about it, that it has nothing to do with the case and we don't have to go further into it, that it was determined to be unrelated, however, which way we're going to phrase it. But we did that. That's only one item. We're dealing with dozens, if not scores of items that are ending up not having any evidentiary value. That's my concern.
Can you begin us?
Yes, Your Honor. Actually, speaking of agreements, I did prepare a stipulation with respect to some of the evidence which has been seized, which was shown to Attorney Schoenhorn yesterday. He requested a single amendment, which I made, and so I'm asking that he and Attorney Felsen review this and hopefully sign it so that we can begin publishing it to the jury forthwith. And I'm also giving him a copy of the proposed photographs that I'm going to be using with Ms. Roy today. He already has these photographs, Your Honor, but I'm giving him the specific ones that are going to be used.
Thank you. I'm going to need, at some point, last night I did go through the draft that Mr. McGinnis gave me, so I'm going to need to chat to him about one of the items on this list. So before that is offered, I don't know if it's better if we do it now or we do it at the break. I don't know what Your Honor prefers.
Well, if we will not get to it before the break, the court would prefer that be discussed at the break.
As with the state, Your Honor, we do anticipate, however, and it's Attorney Manning's witness, so I certainly don't want to speak for her, but my understanding is that the next witness will be not terribly long, and so I don't think that she is going to be taking us to the first break. So we could discuss it now. I could go downstairs and perhaps make an amendment, but without having to bring the jury in and out.
How much time do you need, Attorney McGinnis?
I don't know what Attorney Schoenhorn's referring to, so.
May I just have a moment, Mr.
Yes.
McGinnis, now?
So, Judge, there were a set of keys which were identified as State Police Exhibit 502GG. You'll recall, Your Honor, I believe it was a week and a half ago that Attorney Manning attempted to introduce a physical copy of those keys. Now, the physical copy of the keys, the actual keys, were not received as an exhibit by the court. The court excluded it, I believe, based on relevance grounds. However, a photograph of 502GG was displayed to the jury. 502GG was swabbed by the police department and went for forensic DNA testing. Ultimately, I don't think that there was any profile found on it, but I included it in the stipulation because it was tested. So it's unclear to the state whether or not the court was simply precluding the physical exhibit or whether or not the court was precluding any and all mention of 502GG. So if the court was precluding any and all reference to that, I can certainly take that out of the stipulation.
Well, the concern for the court at the time of the offer was that the officer who retrieved the key.
And why did you swab those particular areas?
I had information that this door was shown to be positive luminol. So what I wanted to test was whether any of those swabbings would have a positive result with the screening test for blood.
Now, as I understand it, luminol can test positive on a number of different materials. Is that correct? Or a number of different materials can give a positive luminol test?
I have very limited experience with luminol. We don't use it in the laboratory. It's a crime scene screening test for blood. There are things that do react, such as cleaning products.
Now, did you observe yourself any blood-like substances or biological materials on this particular door?
No, I didn't see any reddish-brown stains.
Okay. And then specifically, just going to direct your attention now to S3, which appears to be a storage area on the door where things could be sort of inserted in. Did you swab that particular area?
Yes, I did. I swabbed the opening of that pocket. That was designated S3.
Pocket, better word. And S4, what area was that?
Okay, I called that a grill. Maybe I should have called it a speaker, but to me, I called it a grill. So the grill and the pocket, I actually was able to remove. And so S4 is on the panel itself, the opening of that grill, which I had removed. So I went around the edge, the opening, and swabbed that area.
And S5 is near the center of the door, near what appears to be a piece of carpeting near the door or on the door handle. Is that correct?
That's, I called that a fabric panel. And what I did was I pulled up the edge of the fabric panel and then I went around the edge and swabbed the edge of the fabric panel.
With respect to swabs 1 through 5 or 99 S1 through S5, what screening test did you do on those?
I did the O-toluidine test, which again is the more sensitive of the screening tests. And the information I had was that this door may have been cleaned. So knowing that, I wanted to use the more sensitive test.
And
Well, Attorney McGinnis, it's about 1 o'clock.
yes, Judge.
What we will do is just stand in our lunch and recess. Does council need a little more time after the lunch and recess in order to review the notes?
Perhaps.
So what we will do, ladies and gentlemen, is take our lunch and recess today from 1 until 2:15. Please do not discuss the case. And would council approach, please?
Yes, Judge.
Good.